and answer any procedural questions that board members may have. So with that, I will open that up.
Ryan, could you just read that little statement? We need to read that before
Thank you
meeting
so
and
much.
the other one.
Yes, give me just 1 second here and I will pull that up. It may not be a surprise to anybody that my anchor site letter has disappeared on my computer right as I went to look at it. I've got it.
Okay.
All right, I will read the following statement. Due to the increased threat of serious illness and loss of life by the rapid spread of the COVID-19 virus, I, Ryan Castro, the chair of the West Jordan Board of Adjustment, have determined that conducting board meetings at the City Hall or at another anchor location is likely to contribute to the spread of COVID-19 and would present a substantial risk to the health, safety, and welfare of the city's residents, participants, and observers. Therefore, pursuant to Utah Code 52-4-2074, Board of Adjustment meetings of this public body will be held only electronically, and this determination shall expire 30 days from the date the chair of the Board of Adjustment signs the written determination, signed by myself, dated November 11th, 2020. And I will make sure that we introduce that statement into the beginning of the regular meeting as well. And with that, I'll provide Mr. Gardner just an opportunity to let us know anything regarding procedure or anything else about tonight's meeting that would be beneficial to us.
So what you're hearing tonight is Lisa will present a variance for, it's kind of an unusual variance. It's for a parking reduction. And so Duncan, I think that you might be able to comment. Is Duncan still on? I don't know. But so I think what would be beneficial is to hear from Lisa present the findings, because there are the 5 findings required in ordinance and in state law that the Board of Adjustment must find in order to grant a variance. And so I'd hear those from Lisa first, and then I think I'd give the appellant or the variance seeker a chance to respond, and then the Board of Adjustment can, based upon those findings, determine if there is hardship that has occurred because of circumstances related to the property or to some circumstance out of their control. And after you do that, then you can make a determination whether to grant the variance or not. And I'll have Lisa kind of address the application and what it's about. And I don't know if you want her to go over the application in this meeting, or if you want to wait until the next meeting starts at 6 p.m. That's completely up to the board. So.
Yeah, I think traditionally we allow the applicant to present at the regular meeting just so that we get the full scope and public view, as that's the most attended meeting.
I would let Lisa respond or present first, and then the applicant can respond after that. So,
absolutely. Mr. Murray is representing the Board of Adjustment this evening. Is there anything procedurally you'd like us to be aware of before tonight's meeting?
No, I think you're on track. So
great.
I think I would just like to remind you that once we get into the main meeting, it would probably be a good idea to make sure that everybody involved understands the procedures for the meeting at the beginning of the main meeting, and then maybe introduce all of the people involved and what their roles are, just so that everybody's on the same page at the beginning of the main meeting is what I would recommend.
Great, I can do that. Lisa, I apologize, we haven't met. My name is Ryan Castro. Are you representing the applicant this evening? Am I understanding that correctly?
I am representing city staff.
Oh, you are representing city staff. Oh, I'm sorry. Boy,
I
that's,
believe the applicant will have their own attorney. I'm not sure.
And Lisa's one of our planners that works with Larry Gardner.
I'm sorry about that.
Not a problem.
That's why
My
I've
first
got it.
time at the Board of Adjustment here.
That's why I've got notes. Anything else that we need to discuss or questions by the board? Let's see. So I've got Lisa representing the city's position. Mr. Murray is representing us. Mr. Gardner is with Lisa as a planning representative. Any additional city staff participating this evening?
Paul Dodge should be in.
So Paul Dodd's another assistant city attorney. Duncan, what is his role tonight going to be?
So his role is representing the city. So he is working with you and Lisa on representing the city's position.
Yeah. And so the only thing that I would coach the Board of Adjustment on is make sure that those 5 findings of hardship, they all have to be met in order to grant a variance. And you know, and so I'd focus on those as you are looking at this application. And Duncan, as your counsel, can guide and direct you if you feel like, or you can ask me questions about it this evening. But I would focus mainly upon those before you grant a variance or deny a variance.
Well, let me ask you this, if one of them are just for instance, one of them are so cut and dried, the rest of them, you just, I guess you answered the question that all 5 have to be met.
We would still review and document all 5, regardless of any findings on an individual one. I think it's important that we.
So we could find for 4 and 1 be, you know, outside the realm, and then it wouldn't be passed then, correct?
Yeah, correct. And I'd make findings on each one. If you agree with Lisa, that's fine. But this may have a potential to be elevated. Duncan, I don't know if it will or not, but it could go to court possibly. And so a clear record is good for if it does go to court for the city. So
Yeah, this is the only and final appeal within the city itself. This would exhaust the administrative remedies, it's called. And so the only additional review from this body, if someone does not like the decision of the Board of Adjustment, would be judicial review in state district court. So, yeah, and as Mr. Gardner mentioned, you need to have a clear record for the court to review. So specific findings on each of these 5 criteria are essential.
And so I think with that, just from a procedural perspective, I think that just for the board's understanding, we will definitely go through each criteria and discuss them to make sure that we have a firm understanding of their intent, and take a position on those before I'll accept a motion. It's important that we document that appropriately. So just keep that in mind as we walk through it, to have decent conversation so that we can demonstrate our understanding, whatever that may be. All right. Anything else? Okay. With that, I'd be happy to accept a motion to adjourn the meeting in preparation for our next meeting.
I'll make that motion.
Motion put forward by Mr. Heiner. I will second it myself. Seconded by Ryan Castro. All in favor, please indicate with an aye.
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 Aye. And opposed with a nay. Motion carries 1, 2, 3, 4 to 0. And this meeting is adjourned in preparation for our next.
Ryan, I've got somebody raising their hand in the attendees. I think maybe just further explain that the regular meeting is still has to take place.
Yes, absolutely, will do. And I also, Julie, if you don't mind, I'm going to watch. I'll mention the Zoom hand functionality there, and we'll watch that during public comment. I think we'll use that to be the driver for our public input.
So I unmuted Coulter Tadioka. I don't know if that was what their question was.
Yeah. So those of you just joining us, our meeting, our pre-meeting has concluded, and we'll begin our traditional meeting here at 6 p.m. sharp. I will provide some basic coverage of the way the meeting will operate and some guidance there, as well as explain how you can have an opportunity to provide public comment or participate as appropriate. So just hang tight and we'll get you in there if needed.
I'm showing 6 o'clock.
Sorry, basement lights is not.
All right, 6 p.m. we will begin. I call this West Jordan Board of Adjustment meeting to order. Today is December 8th, 2020. And before we begin the meeting, I would like to read the following statement. Due to the increased threat of serious illness and loss of life by the rapid spread of the COVID-19 virus, I, Ryan Castro, the chair of the West Jordan Board of Adjustment, have determined that conducting board meetings at the City Hall or at another anchor location is likely to contribute to the spread of COVID-19 and would present a substantial risk to the health, safety, and welfare of the city's residents, participants, and observers. Therefore, pursuant to Utah Code 52-4-207-4, Board of Adjustment meetings of this public body will be held only electronically, and this determination shall expire 30 days from the date the chair of the Board of Adjustment signs the written determination, signed by myself, Ryan Castro, dated November 11th, 2020. And with that statement, we'll continue. Present this evening, we have Board of Adjustment members, myself, Ryan Castro, Mark Warner, Dallin Anderson, and Mr. Bill Heiner, being represented by Mr. Duncan Murray, who is present and representing the Board of Adjustment this evening. So we may interact with him if we need some guidance or counsel. And then representing the city this evening, Lisa Elgin from City Planning, as well as Mr. Gardner, City Planner, and then Assistant City Attorney Paul Dodd. Those are the participants that I am aware of thus far, and we will get other participants read into the minutes as we move forward. So just some procedural items I would like to clear up. So this is an electronic Zoom meeting, and there is a portion of the meeting which will be open for public comment. As such, Zoom has a hand functionality, the ability to raise your hand as an attendee. At the appropriate time when the meeting is open for public comment, we will use that as a signal that you wish to provide input to the public portion of the meeting. So make sure you're familiar with that functionality, and we'll make sure that you get an opportunity to provide input or participate as you feel needed. But like I said, there's a time and a place for that, and we'll make sure that that comes as it should. With that, we will move with agenda item number 1, which is approval of minutes from October 13th, 2020. Is there any discussion or amendments to these minutes by Board of Adjustment members? And if there is no discussion and you're satisfied with them, I'm happy to accept a motion to approve those minutes.
I'll make that motion to approve the last month's meeting minutes.
I second that motion.
Motion put forward by Mr. Heiner, approval of the minutes from October 13th, 2020, and seconded by Mr. Anderson. All in favor, please indicate with an aye.
Aye.
Aye. And any opposed with a nay. Motion carries 4-0. Minutes are approved, and we move to the next agenda item. Item number 2, Utah Fusion All-Stars variance, 9902 South, 6150 West. Variance requesting the reduction of parking from 65 stalls to 17 stalls and related landscape requirements in an M-1 zone. Emily Morgan, Utah Fusion All-Stars, is the applicant. Lisa Elgin, number 22662, parcel 26-11-326-008. And with that, is our applicant present this evening? So I see a Taylor Morgan. We'll start with Taylor Morgan. If you wouldn't mind, please approach and state your full name and address and your role in representation this evening.
Thank you, Mr. Chair. Can you hear me okay?
Yeah, you sound great.
Thank you. Can you see us, or are we just on audio?
I only see audio.
Okay, I don't see a way to activate video, but you're happy to do whatever you would prefer. I'm here with, Emily is with me. We're here together.
Just one question. I see a Coulter, their hand up as well. Are they representing with you?
That would be our attorney, Derek Coulter.
And Mr. Castro, I don't know if you can hear me or not.
You sound great. Yes, sir.
Okay. All right. Yeah, I was have been retained to represent the Morgans. I had just a brief outline of some things that I would like to present to you, and then I think the Morgans would also like to share a couple of comments if that's acceptable to the board. I'll try
Absolutely.
I'll be happy to keep this very brief if that's something that is acceptable. So,
if the Morgans are fine with it, then we will have you open with a traditional name and address, and then you can allow them to step forward and represent together. That sounds great. Okay.
Thank you. My name is Derek Coulter. I'm an attorney down in Draper. I'm with the practice of Coulter Tadioka PC. Address is 11576 South State Street, Suite 503, Draper, Utah 84020. First, I want to thank you for the time and attention spent to consider this application. I do a fair amount of this work, and the analysis and feedback from the planners, from Lisa and Larry, were some of the very best that I have seen. It's something similar to what we would get out of Park City, but most of the municipalities don't do nearly as good a job as they have on this case. And the applicants are disappointed the application wasn't approved, but given the consent, given the consent and feedback from the neighboring property owners, we had really hoped that this variance would be approved. But given the analysis, I think it's primarily by Lisa, we understand the city's position much better. We understand the position of the city in denying the variance. I would like to just take a couple of brief moments and address a couple of issues, dealing with the background facts, some short-term concerns, and then propose some solutions if I could. First, dealing with the background, in the facts that are there, I think there's a little bit of miscommunication on the intent of the parties at the beginning. I represent the property owner, Mr. Short. I've represented him for I think since 2002 or 2003. And later, the Morgans asked me to assist with this issue as well because of some of the miscommunications primarily related to their licensing application. But just to be clear on a couple of things in the background, there was no intent by the owner or the Morgans to do something in a way that was anything other than cooperative with the city. The staff report makes it sound like there was 5,000 square feet that was going to initially be leased, and then it turned to 12,000 square feet. And there was communication with the owner. And I think part of the communication problems here is that it wasn't really dealing with the owner, it was the communications with the owner's architect and engineer and some others. And I think that led to some miscommunications because there were different proposals. But that being said, there wasn't something from the owner that was represented to be something that was untrue to the city. The second point here is that the city has kind of taken issue with the Morgans as far as operating their business when they didn't have their business application, and which is including the conditional use permit and the variance for the existing location. Just real briefly, they thought that this was something that they could transfer from the other location they were operating out of West Jordan to this location. They've been in business for 9 years, and they've tried to be, a good, community business that's been provided to the youth and been a good business partner with the city. But the other issue here that the city has raised kind of is that there was notices provided to the owner and the registered agent. And I've talked to Paul Dodd about this earlier, is that some of those notices issues here, I know that's a little bit beyond the scope of the variance, but we really have to take some exception with some of the notices issues because I've been the registered agent for most of these companies that we've held title to various properties for at least 15 years. And I've been in the same location since 2003 when I bought this building. I've never received any notice. And so when we looked at the notices that were provided, they were provided to an address for the owner that was more than 4 years ago. And then nothing came to the registered agent. So we want to solve the problem, but we just want to clarify that we, as the owners, we weren't aware of this until the Morgans brought this to our attention. Then we decided if they're, to get involved to see if there's something we can do to help solve the problem. And finally, on the background here, we do appreciate the staff's cooperation and assistance in getting the conditional use permit and the variance applications filed. These are something that with the variance application, these aren't something that very many people jump through, but the staff has been very cooperative in doing that. We've kind of talked about some of the miscommunications, but we've kind of come to the conclusion based upon the analysis that Lisa has provided that it's not likely to meet all of the requirements in the current location, and we'll have to look elsewhere to operate the business. And with that conclusion, I think there's a couple of some short-term concerns, and then there's some proposed solutions that we would just like to discuss real briefly. The short-term concerns here from the staff observations were really dealing with the safety of the kids attending classes. There was 3 dates that were observed, November 12th, 18th, and 19th. And right now, just for the context of this is a CMU building. It's like a warehouse. There were a couple of other tenants in the warehouse. Those other tenants now have left. So what we've got is a medium-sized warehouse or a smaller warehouse. And the only tenant right now in that is the Morgans. And when there has been issues with parking, it's because the other tenants were in the process of moving out that caused some traffic congestion back on November 12th. On November 18th and 19th, where there was some congestion observed, was when there was a filming, the business was filming some sort of event, and Mr. and Mrs. Morgan can probably speak to that. And there was some unusual traffic that's there. But the other short-term concerns are really the parking issues, the pickup and safety of the kids during their drop-off times. That's something that really we are concerned about based upon the observations that's there. And just dealing with the proposed solutions, given that it's pretty unlikely to be able to meet with all of the requirements for a variance based upon the analysis, what we're asking for is a short term to locate, or a short time to locate to another location. But we also, in the meantime, want to ensure the safety of the kids and the parents until we can get moved to a different location. Mr. Morgan is going to speak to a couple of those proposals on the short term, but we would request, no more than 60 days to find a location, and we're willing to pay for whatever fee, emergency temporary fee or something like that, to be applicable until the business can be moved. And we're also open to other suggestions and recommendations. It just, once we got the staff report, we were pretty disappointed that this isn't something that we couldn't work out a solution. But again, given the analysis, it just doesn't appear that we could practically do that. It would just cost, tens or hundreds of thousands of dollars to modify the existing location to operate the cheer school where it's at. And it's not economically viable. So we've got to find a more suitable place to do that. And kind of given that analysis, Mr. and Mrs. Morgan are just going to talk about a couple of short-term concerns or consideration to address those concerns real briefly.
Hi, this is Emily Morgan. Can you guys hear me okay?
You sound great.
Thank you. I appreciate you guys meeting with us. Sorry. So going through some of the.
So really quickly, looking at the analysis on page 3 is where the safety concerns, the observations are noted. We have, obviously, we're very concerned about the safety of the athletes. We have a policy for pickup and drop off, but I think enforcement of that or following the policy among our parents and participants has become quite lax. We have recommitted, we have provided some notices and communications to all staff, met with staff, and communicated with all parents and athletes actually just a few hours ago tonight about the concerns and the observations of the city, implemented some changes in policies there. We have received permission from the building owner to use the rear parking area for staff parking. We've instructed our parents to never allow children to cross the street or to cross to the building from an adjacent parking lot. And so again, in short, we are going to relocate. We love West Jordan. We really appreciate your time and energy on this. It's pretty clear that we need to move, and so we plan to do so. We just would hope that you would give us a little time to do that, and we want to ensure the safety of all of our participants, during that period. And we will happily do whatever we can to comply and to work with you and follow your guidance in doing that. We're happy to address any specific questions or concerns you have. I think that fairly well sums up our position.
Thank you very much for Mr. and Mrs. Morgan and Mr. Coulter. I apologize. Just as a brief moment there, we're in an interesting situation as a board because, like Mr. Coulter said, we very much have a very strict criteria outlined by law, and it's up to us to make sure that we read through that criteria and you know, assess things properly and as straightforward and fairly as we can. So I think it just one of those things where I can tell that this is a difficult situation for everybody involved, and I appreciate you guys coming to speak with us this evening. I have just a quick question for the board's representation, Mr. Murray. Actually, I don't. One more clarification for the Morgans. So is your intent to, I want to be very, very clear, is your intent to withdraw this application and we relocate? Or is your intent for us to continue with this proceeding and see where we come out?
Sorry, Derek, did you want to speak to that?
Sure, and I don't know. I'd have to probably, have a discussion with council, with Paul or Duncan on this issue, because, if we withdraw the application, I need to kind of know from the city's perspective what their expectations are at that point. Or, I know that the variance request is going to, once the decision is made by the board, the applicant would have 30 days probably to appeal to the district court. And so if it's something that it's better to have this in place until that 30-day period lapses, but I would probably need to defer or have a consultation with Paul or Duncan to kind of talk about what would be best. And here again, we ultimately know that this is a location that we can't make economically viable for this business. But we also want to make sure that we can, do this in a way that is not going to completely destroy someone's business or their livelihood, and allow them to a reasonable period of time to locate to a different location. So I don't know if the decision right now, Mr. Castro, has to be made whether we're going to withdraw it tonight, or if it's something that I can have a discussion with council in the next few days and then provide an answer to you or not. Is that acceptable?
As I appreciate the explanation, I'm actually going to confer with Mr. Murray here. Like I said, he's representing the board, and this is a unique situation for us. So I want to make sure that we do our due diligence. Mr. Murray, can you help advise us a little bit here on the best way to proceed?
Sure. I mean, obviously, the only item before you that you have jurisdiction over as a Board of Adjustment is a variance from the terms of the land use ordinance as described here in the application on your agenda. So your ability is to simply act on that variance application. And so obviously your options are to go through the analysis and either grant or not grant, depending on your analysis. So you don't have any authority, though, to enter into other settlement negotiations per se, right? You're just acting on the request. Although you do have the ability to table and reconvene the acting on the variance at a later time. That is another option that is available to you. If you felt like as a board it would be advantageous to allow the city and the applicants to see if they can work out a resolution. And obviously that's up to what they can work out with the city as far as maybe getting some latitude on some additional time or so forth to relocate. But that's not within the purview of your decision-making ability. That would be up to city staff. But if you wanted to facilitate that, you could table any action this evening until, say, your next meeting a month from now. And then depending on what's occurred by that time, finish acting on the application for the variance at that time, if that's helpful. Those are basically your options.
That's very much helpful. Thank you very much. I'd also like to recognize Mr. George Wynn has joined us as a board member. Good evening, George. Were you, so we're going to close the applicant's portion for just a moment here. and I'd like to discuss with the board. Mr. Nguyen, were you able to hear the entirety of the applicant's presentation?
No, I've not heard the entire presentation.
Okay. Board members, do you have any thoughts as the way to move forward? So I do have some thoughts, but I'd like to give you an opportunity to discuss it first, and we should.
Mr. Castro, before we move on to the board's discussion, would it be okay if I, on behalf of the city, just address a few points brought up by Mr. Coulter?
Yes. Yeah, as a matter of fact, that's more than appropriate. Mr. Dodd, that sounds great.
So as Mr. Coulter was discussing, what would be the best avenue, obviously, as Duncan addressed, the issue of this variance is kind of seen as an independent issue related. The way this started was there's been a code enforcement action that's been going on with the city that I've been working with the owners and Mr. Coulter on. And that's the reason why he's talking about asking for more time. And as far as the more time issue and this, they're two separate issues, as Duncan, as Mr. Murray pointed out, that the variance issue and that issue are completely two separate issues. So if, if the applicant decided to withdraw his petition, we could resolve those issues of time with him related in the code enforcement case. And we have a hearing already scheduled in that case on Friday, the 18th of December. And so there will be an opportunity for us to, get together and see what we could work out with the applicant on those issues. So if the board, if the applicant did withdraw his application today, there's still going to be an opportunity. There has been no decision made by the city as of yet on how to proceed with the enforcement of, the code enforcement issues. And we could work out a resolution with them on the 18th. So to answer Mr. Coulter's question of, whether or not withdrawing, what position would that leave them in? I don't think the variance changes, if they withdraw it, it doesn't change anything as far as us meeting together to try to resolve this issue going forward. And I think the city has the same goals as Mr. Coulter. We want, we want Fusion All Stars to be here in West Jordan. We want them to be able to operate their business and be successful. We want them to be able to stay here in West Jordan and do that. And we're willing to try to work with them to do that. But, also we do need to follow our own ordinances as they're established and set up. But so if the applicant does decide to withdraw the application, we do have the opportunity with the hearing coming up next Friday, the 18th, to meet with them and discuss with them and try to work out a resolution as to the location of that business for the short term.
If the applicant withdraws their application, are they in any way hindered from a future application on the same topic?
You mean for this same property, the same issue?
Correct.
I think that'd be a question for Duncan.
The reason why I brought up the option to table for until your next meeting for approximately 30 days is primarily one of saving the filing fee and then seeing if the other matters of code enforcement are resolved first. Technically, I mean, it's not like there's double jeopardy or whatever. I think technically if they withdrew the application, they could probably refile it under the way our ordinance is written. What we're looking at, though, is, it is a fairly significant filing fee. If it's tabled, obviously it's the same application. There's no new filing fee. Obviously it could not be tabled indefinitely, but certainly the city code does allow for you to table for at least one meeting. So
Mr. Castro, this is Larry Gardner. Can I say something?
I'm going to stop you for just a second, Mr. Gardner. I apologize. So I'm in a situation now where we either need to proceed forth. Paul represented the city from a legal aspect, I think, and and put forth his perspective after the applicant did the same. I'm in an interesting spot. Yes, Duncan.
Yeah, so I would say, Mr. Chairman, that'd probably be, and I think this is probably where you were leading, I would recommend that you allow for a response from council for the applicants as to Mr. Dodd's comments.
Yeah. So, and I see that Mr. Coulter does have his hand up, so we'll give you an opportunity to respond to Mr. Dodd, if you would, please.
Thank you. Can you hear me okay?
Yep.
Okay. Mr. Castor, and Mr. Murray, I think given that we've got this review hearing on the 18th, if we could table this for 1 month and then deal with whatever we can deal with next Friday, I think that would be helpful. And then hopefully we can get a resolution. And then if we get a resolution next Friday on something, we can always provide notice to the city that we're withdrawing the variance request. And then it's just a matter of a routine ratification or approval of that, or recognition of the withdrawal by the boards, at some point next month. But I think it would give us time to work with city council to just try to work out a solution to this for next Friday. So to the extent that we could, I would just request that it just be tabled and then allow us to try to see if we can come up with a solution to address all the rest of the concerns, because I think the city does have really, legitimate concerns, and those are concerns that we're concerned with as well. But if we withdraw this and then for whatever reason, who knows what, I just want to preserve as much latitude for the applicants as possible, until we can fashion some way to satisfy the city's objectives and the applicant's objectives, to make sure that we can all kind of work together and get some solution done. So to the extent that we can, if the board is amenable to tabling this to a final decision by next month, by then we should have a decision, and we can just probably withdraw the variance request at that point.
Thank you very much, Mr. Coulter. So I'm going to close this conversation for a moment here and discuss this with the board and perhaps council. Board members, what are you thinking? Like I said, I have an opinion here, I think, but I'd like to hear what you're thinking, and we can discuss a little bit and see if we can come to any conclusions.
I think from my perspective, I think we should table until the next meeting based upon all the factors and hearing both sides. I think that makes the most sense. And then we can evaluate the variance at that point.
Thanks, Mr. Ray. Anyone else?
I tend to agree.
Yeah, I would.
Go ahead.
Go ahead, Bill.
I tend to agree with Dow on the table, and it gives everybody involved more time to work things out. It's, to me, based on the criteria, it's going to be pretty tough to get a variance anyway. And if we can give the applicant more time, that would be great, and to give them an opportunity to show them we're working with them, and hopefully they keep their business in West Jordan, and hopefully they feel like we've worked with them.
I would agree. I don't really think it's going to hurt to give them a little more time, unless there's a major safety issue. I think that needs to be looked at pretty hard during this interim period. But I would say if they can work things out on the 18th and possibly get some other agreements with the city, which is beyond our jurisdiction, then they may very well withdraw the variance, and probably will, because based on the findings of each criteria, the findings of fact, it's going to be difficult for them to get approval of this variance anyway. So I would agree to table it, and we'll see what happens after the 18th, unless there's any other real safety issues or anything that they're dealing with.
Yeah, so I think we're all kind of coming from the same place. You know, as far as the safety issues, definitely a huge concern, but not something our board is responsible for remedying through the approval or denial of a variance. But certainly as citizens, we're invested in that. Honestly, from my perspective, I think I agree. What I have heard is that both parties think that they can resolve this without us having to identify or test the variance at this time. And I don't know that I feel comfortable testing the variance this evening based on what's been said. I'm also aware that based on what we've heard from the applicant, just being very upfront, you know, it's as a small business owner, it's an expensive fee, and it's a worthwhile fee, but that much is enough to everybody. That's trying to be as transparent as I can. And so I also am pretty invested. If this, I don't see any downsides. Like I said, I don't feel comfortable testing this particular item this evening, given what's been said. I do feel like it's certainly something that we can pursue, but I'd like to give the city and the applicant the opportunity to see if they can resolve some of their other concerns and see if the variance moves forward. With that, I would be happy to accept a motion to table this until our next meeting in January of 2021.
I could make a motion that the application for a variance to reduce parking requirements and landscape requirements be postponed and tabled until the following meeting.
I second that motion.
Motion put forward to table item number 2 in our agenda, variance requesting the reduction of a parking from 65 stalls to 17 stalls by Emily Morgan, Fusion All Stars. Seconded by Mr. Anderson. Motion was put forward by Mr. Warner and seconded by Mr. Anderson. All in favor, please indicate with an aye.
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 Aye. And then any opposed with an audible nay, please. And that motion carries 5-0, and this topic is tabled until our meeting in January of 2021.
Ryan, can I just clarify for the people who are on the meeting that would be January 12th?
Thank you, Julie. Yes, our next meeting is Tuesday, January 12th, which I think is also public noticed. Let's see here. Thank you very much, Julie. So with that concludes our agenda. As a chairperson, I just want to thank the applicants and city staff. City staff clearly has put significant effort into this application. As always, they're very professional. Also, really want to thank the applicants for genuinely approaching the board. Like I said, our role is very specific here. But I really appreciate, as a citizen of West Jordan, everything that our small business owners do for the community. So thank you very much for approaching us this evening. If there's anything else from the rest of the board, feel free. Otherwise, I will. Oh, we do have. Mr. Murray.
Yes.
Procedurally, are we perfectly fine for the Morgans to offer comment?
Yes, I mean, if they have some kind of point of clarification, you can recognize them as the chair.
That's great. I would love to. Morgans, please feel free. What can we help you with?
We're sorry to interrupt. We just wanted to thank the board and thank Lisa and the city, and we look forward to working with the city and code enforcement, and just appreciate your time.
Yes, thank you. Sorry that I was emotional. I appreciate you guys very, very much. So thank you for taking the time out tonight.
Thank you, Morgans. With the board, any remaining comments from the board? Otherwise, I'll accept a motion to conclude or close our meeting.
I'd like to put forward a motion to adjourn the Board of Adjustment meeting.
I'll second that.
A motion put forward meeting put forth by Mr. Anderson and seconded by Mr. Heiner. All in favor with an audible aye, please.
Aye.
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 And any opposed with a nay? The motion carries 5-0, and this meeting is adjourned.
Thank you.